Hey everyone, thank you for coming to our snowed in lunch and learn. I owe you lunch now, but at least you're going to get the presentations. Today we're going to be talking about planned giving, and then we're going to bring you another videoed recording of intellectual property. So today with me is Cy Alfred. He's an attorney with our firm, and he's going to be leading us through this planned giving, and I'm going to be chiming in here or there. So Cy, please take it away.
Absolutely. Thank you, John. So, planned giving is one of the topics that has consistently come up in our practice. We work with a lot of nonprofits, churches, and ministries. And so, naturally, this is an issue that we consistently see on a regular basis. So, we wanted to kind of give you a 30,000 feet overview of some of the major topics in this area, hopefully, to just help you conceptualize a little bit of what we see from the legal perspective, but also to give you some verbiage for how you can best help your own people, help your donors, help your members, whoever needs this kind of assistance. This will hopefully help you give you some context in this world. So, the big objectives that we have that we want to kind of explore are the major legal mechanisms for planned giving. You'll often hear us refer to planned giving or estate planning. We're often talking about the same mechanisms here. We're also going to give you some of the common pitfalls, the problems that you need to know, and as well as some practical steps for implementing some planned giving strategies. Absolutely. If you have any questions about anything that we go over, please feel free to email or call John or I. Obviously, if we were in person, we'd be able to kind of do it live and answer any questions that you have. But please feel free to reach out to us if there's something in here that you have more questions about. All right, so what's at stake? Why does this topic matter? There are three key reasons that John and I have keyed in on. The first and foremost is that we want you guys, and you guys obviously want to align with a biblical standard of stewardship and legacy building values. Those things are crucial, especially for continuing out your organization's mission. Um, Biblical stewardship we define as, everything that we do to handle our money, but also everything that we eventually pass on. And that is what estate planning or planned giving is all about. It's about the assets that we pass on to future generations and even organizations that we support even after our deaths. The second big stake here is that the planned giving is incredibly crucial to long-term stability. A lot of the mechanisms and the instruments of the law that we're going to be talking about are designed to help you create long-term stability, not just through donations, but through different forms of donations, which we'll talk about. And finally, last but not least, you mentioned the great wealth transfer. The New York Times stated that there's roughly $140 trillion worth of wealth represented in the US, and about half of that is owned by the baby boomers, which means that that $70 trillion is going to be passing over the next 20 years to the next generations. That's crucial. That's big. That means that a lot of that money is going to be used to hopefully help a lot of people out, going to different organizations in different forms and capacities. So, with that, estate planning and plan giving is extra crucial over this next 20-year period.
And one of the things we're seeing, Si, on that is that people who are thinking about estate planning, older baby boomers, are literally saying we'd rather give our money to charity than let the government tax it. And so there's a high level of motivation to look at some planned giving tools right now. It's a statement we're hearing over and over and over again.
That's right. That's right. And so some of those common plan giving tools that we see on a regular, consistent basis are bequests through wills and trusts, retirement accounts and life insurance policies, and then lifetime gifts. We're going to go through each of these three common types of plan gifts, and then we'll kind of handle some more advanced stuff a little bit later as well. But to set in on wills and trusts, it's funny because when we were preparing for this, John was like, "Sai, you spent way too much time describing every and all the ins and outs details of all these. Just give them the basics." And I was like, "Okay, I can do that." So the key elements of a will that you need to know are a will is going to, one, devise property or devise assets and give those assets to beneficiaries. And two is that a will is going to appoint an executor, and that executor is going to oversee all of the assets of the person creating the will going towards those beneficiaries. That's the nuts and bolts. That's the basics. There can be all kinds of interesting things you can do with wills as well as trusts, but those are the basics for a will. A will also has to be probated, which means the executor has to go before the court or a court of competent jurisdiction and probate the will, which is a legal proceeding. The next instrument that we see is what's called a trust. A lot of people have misconceptions about a trust that, you hear about trust fund babies or you hear about, this exorbitant amount of wealth that goes into a trust, and that's absolutely true. But a lot of trusts are used for even more nominal sized estates, especially where property is involved, because trusts remove that property within the trust from the probate process, which is a big time saver and money saver, which is why attorneys, financial advisors, we all like to recommend trusts. The basic operation of a trust is similar to a will, but instead of, in a will, you have an executor. In a trust, you have a trustee. And the trustee handles the property within the trust. Now, trustee has a greater range of responsibilities because the property in the trust can be held in trust for a specific amount of time. And so they have a much greater responsibilities like maintaining the property. They can sell the property. They can transfer property in the trust. There's all kinds of responsibilities. But the trustee is doing that on behalf of the beneficiaries. Similar wording there with wills as well. So the beneficiaries are going to receive the trust once the terms of the trust have run. And so, what does all this mean for you? Well, what happens if someone dies and they've made promises to your organization? Sometimes this person could have a will, sometimes they could have a trust, sometimes they could have both. Sometimes they don't have either one of these assets or either one of these tools. And so what's going to happen if somebody dies and they've made promises to your organization can vary depending upon what instruments that they have in place. So the biggest thing that we like to emphasize to our clients is that the death certificate, and this may sound strange, but bear with us, the death certificate is the most important document that you can obtain, especially if somebody has made a promise to your organization to donate a specific amount of money. The irony, the catch-22 is the death certificate is also the most difficult document to obtain if you're just an organization receiving from somebody's estate. It's often because state law around obtaining death certificates is very restrictive on who can obtain those death certificates. But you can make it a lot easier on yourself to obtain a death certificate or otherwise if if somebody who comes to you and makes a promise to your organization, if you just follow up with them in that same conversation or in another conversation, hey, can we get a copy of your will, or can we get a copy of your trust, or hey, can we talk about this a little bit more so that we can kind of get some written documentation around this promise that you're making? John's got some stories, and I'll kick it over to him right here. But this is oftentimes a huge problem that we run into.
Yeah, that's probably not something you're going to hear very often from attorneys or estate planning or plan giving folks is get a hold of that death certificate. And the reason why is a practical one, not a legal one. Um, you getting a hold of the death certificate doesn't change your rights in any of these documents. It doesn't change your rights in any of the um, assets or gifts. But what it does is allow you to kind of kick off some of these things. We'll talk about retirement accounts later, but allowing you to send off, a beneficiary request and copy of the death certificate to these IRA account holders or, fund managers, things like that. But what we have, so give you an example. Gentleman gives $1,000 a month to a missions organization. Very faithful giver, elderly giver, about 97 years old. So $1,000 a month for a 97-year-old is not a small amount of money. And throughout his relationship with the donor organization, he tells them, man, when I pass away, you guys are going to have a big party. I am taking care of you. Now, this is a small organization. This is about a $2 million a year organization. And so they are anticipating a gift that would very much change their organization. It would be a huge benefit to their organization, be able to expand their mission. And he ends up passing away. He has no family. He has a cousin that they know about who's not contacting the ministry or responding to the ministry's emails. And he has always given through an IRA. And the IRA fund manager has said, hey, if you have a copy of the death certificate, we can let you know if you're a beneficiary or not. So this is a practical application of this where nothing's going to happen unless someone probates this guy's will. Or it gets to the point to where the fund manager has policies or procedures that say, hey, it's been a certain amount of time. We can now go look for this. And so it's up to them to try to find out, figure out how to get a copy of the death certificate. And depending on the state they're in, it may be very difficult. This is a pretty common scenario where someone walks up to an executive pastor, a senior pastor, a donor development guy for a missions organization, and just says, hey, just to let you know, my wife and I have left X amount or X percentage for you in our will. Telling them thank you and have a great day may seem polite, but it doesn't help the organization at all. It's very important at that moment to say, hey, that's wonderful. Can we talk about that for a little bit? Maybe provide some documentation of our file. We just want to make sure those funds are adequately distributed or that they are distributed upon your death, since we won't have any control. There are times where they may get a response such as, well, will you be our executor? Will you be our trustee? And that's something that you have to think about. It does carry some duties, but we do see a number of pastors named as executors in wills and trustees and trusts. So,
Yep, that's very true. And if you're ever in that position and you don't know what to do, please feel free to call us and we can help out. We can at least give you some basic guidance that won't make that seem as intimidating as it actually is.
and
Um,
just if you're wondering how common this is, I've gotten two calls in the last 24 hours on this specific situation, three in the last week. So this happens pretty regular, where someone says, "Hey, we think we've been left a gift," and either the other side's attorney is not releasing information to us. There could be a reason why. It doesn't mean they're doing anything wrong, or we don't know where to start. This person was very wealthy. We have also found that people make promises that they can't keep. That they say, "I'm leaving you millions of dollars," and there are no millions of dollars. So definitely something to keep an eye out for.
Nobody would ever do that, John. Now, come on.
Happens all the time.
Well, the final common type of estate planning tool that we see, and John's touched on this a little bit, is retirement accounts and life insurance accounts. And these are pretty cut and dry. They're not usually open to contestation, or they're not open to a lot of controversy because the named beneficiary on these accounts is going to receive the money. That's just the bottom line. Whoever is named with the organization holding the retirement account or the life insurance, that is the individual or the organization that's going to receive it. And you don't have to have any legal proceeding to determine that. It passes what's called outside of probate, and so it's very cut and dry. And whatever entity holds that retirement account or life insurance proceed is often going to have their own process for how you're going to go about collecting that money. And so oftentimes, this is where we mention the death certificate. That's going to be necessary, or at least you're going to have to show some kind of writing, or just being as the named beneficiary may be enough. But there may be some additional steps depending on the insurance company or the retirement company that holds that account. Many times, you're often going to be working with an executor or a trustee, kind of hand in hand, to make sure that these funds are dispersed. Sometimes retirement accounts, life insurance accounts, they'll have multiple beneficiaries listed. So you may end up getting 25% or a certain percentage amount of these accounts. So you're going to want to know who these executors are, know who the trustees are, and work with those individuals to receive these disbursements.
Oftentimes, when you're working with a fund manager that needs to disperse funds to you because you're a beneficiary, they will excuse me, they will often require some sort of administrator or trustee appointed on behalf of the organization. So it's not uncommon for our clients to get forms that say things like, hey, you're going to be the administrator or the trustee for this organization. We need to know your personal information, your address, your home address, uh, your social security number, things like that. And that can kind of be off-putting to some donor development folks or pastors to say, hey, I'm not giving out my personal information. This is a work thing. That's something that our firm has served as a trustee for those sorts of situations. But oftentimes they'll require you to actually set up a fund with their organization for them to move those funds in. And depending on the type of account it sits in, 401k, an IRA, an investment brokerage account, the rules are different. And so sometimes you'll get a check right off. Sometimes you'll have to set up an account, then write yourself a check, and then close the account. There's all sorts of things you need to do. So you need to be ready for some hoop jumping on some of this stuff.
So we're moving out of the basic types of vehicles that we see in estate planning. And or there's one more topic, but I'm going to kick that over to John, and then we'll move on to the more extensive ones.
So lifetime gifts. These gifts are usually substantial gifts that people are giving during their lifetime, obviously, while they're in relationship with the organization. And these are great gifts because you get them immediately. You don't have to worry about probate. You don't have to worry about upset relatives. Um, one thing I would tell you on donors is if you have a donor that you are concerned about their capacity, do they have the mental ability to give the gifts? That is something that we would need to want to discuss before that money's spent, even if it's given to you. So let's go over gift agreements. Gift agreements are something that you would see typically if someone's giving a major gift and there's some strings attached, but not so much that it violates 501c3 rules to where they can't get a tax deductible gift. A lot of times you see these with institutions. I'm going to give you $1 million and you're going to name the building after me, and you're not going to rename it after anybody else unless they give $10 million, and then you can rename it. Things like that. Or, hey, you're going to use this for this land or that land. So this brings us to kind of restricted and designated gifts. This is kind of a gift agreement that's not written. This is an oral gift agreement, oftentimes or implied, where a restricted gift is something that a donor says, I'm giving you $500 to use toward missions or feeding or to buy a new baptismal or whatever, and you accept that as the organization. That's a restricted gift. You can only use it for that. A designated gift. Well, a designated gift may be one where the board sets up the fund and says, we're raising money to build a new children's area. Give to that. The board has designated that, and the donor gives to that, which means you've made a contract with them. It's going to be used for that. This is often confused with when boards just designate funds. They have a pool of money and from their general fund, and they say, we're going to take $500 and we're going to designate it toward, benevolence. Then what happens if the board changes their mind later on and says, actually, we need that money to pay the light bill, so we're redesignating that fund? It's a question we get often. Once money has been designated, can we change the designation? Well, it depends on whether it's been done by the board or whether it's been done by the donor and whether it was done by the board before the donor gave or after the donor gave. If it was after the donor gave, you can likely change it however you want. So that's what we mean by written or implied gifts. Gifts between nonprofits, that's you can have any restrictions you want. You're giving it to another 501c3. There's no prohibitions on that unless it's being used for illegal uses. And so, if they want to use it for something, you don't have to worry about, is this a tax deductible gift? Other than, is this for a legitimate nonprofit purpose? So you have to use your funds for that. But even if it's to another nonprofit, those restrictions are less and less. So if you have questions about these gifts between organizations, let us know. Gifts from individuals. Gifts from individuals, they can only be deductible if they're for the nonprofit's purpose. If they're to benefit a private individual, they're generally not. The biggest thing we come across for churches and missions organizations is when you're designating like a family. Hey, this money is for the Smith family in Zambia. And can we do that? Usually you can request a designation as the donor. We request that this goes to the Smith family in Zambia. And oftentimes the organization will have somewhere on the website, hey, we will take your request in consideration, but we have the right to use the gifts as they need be for the mission of the organization. This is usually sufficient to get away from the IRS prohibition of using for individual benefit. And I will tell you, most churches and organizations honor that request when they can, and that it's not much of an issue. So, land donations. This is full of problems. We really encourage our clients, hey, if you're being offered a land donation, please, please, please contact us. Give us 30 minutes of your time. We need to check just a couple things. How is the land zoned? Is it going to be able to be rezoned for the purpose that we're going to use the land for? Is the land particularly valuable? Maybe we need to think of some other type of mechanism for holding it. We'll talk about that in a little bit. Is the land hazardous? Has it been a dump, a dry cleaners, a gas station? Are we going to even be able to get a loan to put buildings on this land because we can't pass the environmental test? We had a client years ago that was given what appeared to be very, very valuable land off the side of an interstate. They were very excited. And when they got the land, it was hundreds of acres. Come to find out, the land had been a dump for years. All of a sudden, the land became worthless. All of a sudden, we couldn't do anything with it. And now we're stuck with this land that's nothing more than a useless asset on our books and eventually could become a liability depending on what's around it. And so, very major issue. The next thing you have to look out for are deed restrictions. What restrictions are in the deed? Many times when people donate land, they'll put things in there. Hey, if this isn't used for church purposes, then it reverts back to the owner. It could be denominational deed restrictions if you're getting it from another church or ministry. There could be deed restrictions that have an HOA or property owners association restriction on there. That can be an issue for developing the land. And so it's very, very important that when someone says, I want to donate land to you, that you don't say, this is great, fantastic, we need the land. Uh, you actually take a look at it. You may never be able to sell it. You may never be able to use it. It may just become a tax liability for you. And so
Quick,
please, 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 when someone wants to donate land, take into consideration. The 501c2 is an interesting organization because what it does is it allows you to take the land into a nonprofit corporation that's separate from your 501c3, protects it from the liability of the 501c3, and it allows it to get tax exempt status from like your county appraisal district in most situations, not all. Um, and so if you are getting a particularly valuable piece of land, especially if it's like in an urban area or something like that, talk to a nonprofit attorney about putting it into a 501c2. It's just a different type of nonprofit corporation. It has a board. It's for the benefit of your 501c3, your church, your ministry, your charity. But this really may be something that you need to consider.
a quick note on deed restrictions. Those can be really tricky, especially if the original deed was given with any kind of reversionary interest. Like John was saying, if the interest in the property is to be used only for religious purposes or whatever those purposes are, and if the property is not used for those purposes, that land can revert back in ownership to a previous owner or an heir of a previous owner. And so you get into this really messy situation where if you'd called somebody or looked at the deed records, you'd be able to see, oh, this land is encumbered. And so that's why we like to say, hey, let us know if you're getting if you're getting property from anybody, not just for the financial implications that it could have just because it's profitable, but also because it may become a huge legal liability as well.
One final story on this deed restrictions that's it's kind of interesting is that if you have particularly a church building or a ministry use building that was owned by a denomination, especially from decades ago, you see this less often today, but especially from the early 1900s through the 50s, there may be a deed restriction that says this property will be deeded to the church only to be used for this denomination. And once it's no longer used for this denomination, it reverts back to the denomination. And this could be Church of Christ, Assemblies of God, anything like that. And so this is something that you really, really need to pay attention to. Uh, this is something that when you buy property, you need to take it seriously. And so I would just encourage you, don't brush over those things. We actually do need to read the deed. The donor, do you want to talk about the SI?
Yeah, I can a little bit. So donor advised funds, these are donor directed funds, and they're kind of given a general or broad authority to give money to different 501(c)(3)s and charities. Oftentimes, you give to a donor advised fund, you're getting a tax deduction for that money. There is a difference in the rate depending on the between the donor advised fund and the private foundation, but you are getting a tax deduction. And then, John, can you talk about the receipt
Yeah,
and acknowledgement?
absolutely. So we're seeing more and more churches get gifts from donor advised funds and private foundations where people are saying, hey, we're not going to give to you personally. We've already given to donor advised funds and we've already given to a private foundation and it's going to direct the money to you. Here's why they do that. Here's the rationale behind it. When someone gets a big amount of income, they sell a business or, they have some capital event and they want to put a significant amount of money away to be able to deal with the charitable giving later. They don't want to do it all at once. Let's use a big number. Let's say it's $10 million. They get $10 million and they want to put half of that in a donor advised fund. They get a tax write off, like a donation for half that, for $5 million. So now they're only taxed on that remaining $5 million. And then they have $5 million sitting in their donor advised fund. Then they can disperse as they wish um, to charities of their choice. Here's the deal with the donor advised fund. The donor advised fund is a 501(c)(3). It is a charity. That's why they're able to get that tax write off. And it's called a donor advised fund because the donor advises the fund as to where they want the money to go, but they're only advising it. The donor advised fund is not required to give it. Now, donor advised funds really wouldn't stay in business very long if they regularly ignored their donors' advice. So, for the most part, we see donor advised funds gladly direct these funds to 501(c)(3)s. Here's where we get a little bit of the hiccup. These donor advised funds have their own policies on who they give to and who they don't give to, often overlooked by the person who's using them. And so they may want a letter of determination letter from the IRS. A lot of churches don't have IRS determination letter because they're older churches or they've never applied for one. They're automatically exempt under the Internal Revenue Code. Or they may be involved in a very large donor advised fund. I've seen major financial institutions do this that initially say, oh, we don't give to religious organizations. Sorry, you'll have to pick somebody else. And it takes a little bit of lawyering, a little bit of fighting to get them to realize that they can't do that. And so we've had some issues with donor advised funds. One of the issues that we have suspected from a few of these donor advised funds is that when the person is saying, hey, we would like to give $10,000 to this organization, the donor advised fund is not giving all of the $10,000. Now, this is very hard to corroborate because oftentimes donor advised funds will send letters to the donating organization or the donor organization that says, hey, here's your gift. By the way, you can't send a receipt to the donor because that would make it look like they made two gifts, one to us and one from you. So we've told our clients if we know who's directed the gifts, which sometimes we do, sometimes we don't. A lot of people use donor advised funds for anonymous giving, to go ahead and send a receipt or an acknowledgement. Sorry, not a receipt, an acknowledgement of the gift. Hey, this is not a receipt. We just want to acknowledge that we received this gift from your donor advised fund. It helps them be aware of whether the donor advised fund is doing what they think that it's doing. This is a little bit controversial. There are some attorneys who say, hey, this never happens. There are others. This is our practical experience that we have had in these situations. You also have to be aware of requests from donor advised funds and private foundations when they're asking for information to make this grant. So we had a particularly rough situation a couple years ago. There was a disaster in the Appalachian Mountains. Um, where a donor advised fund came to the church and says, we have someone who wants to donate to this organization. The person called the church and said, you're going to get an email from our donor advised fund. They're requesting information before they make the grant. And it was a significant amount of information. It was a very lengthy application. They required opinion letters from the lawyers. They required copies of filings. They required copies of the 1023 application, which are not easy to get. They required a significant amount of information. It was all packaged and sent off, and the church awaited their large gift from the donor advised fund, all to receive $250 for disaster relief. While grateful for the gift, our firm actually ended up writing off all of our legal time for that project because just to try to help out the church because it didn't make sense. I mean, our legal fees were 10 times what it was to what the gift even was. And so many times with private foundations and donor advised funds, we're finding organizations are working very, very, very hard uh, for these grants and it's not coming to fruition. This doesn't mean donor advised funds and private foundations are evil. It's just having some realistic expectations as you go into these types of relationships.
So that was a basic covering or understanding of the common methods of planned giving. We want to hit on real briefly some of the less common types. These are a little bit more complicated, maybe a little bit less out of the normal vernacular, but we want you guys to have a basic understanding of what these tools are. So we're going to touch on charitable remainder trust, charitable gift annuities, and then also church foundations and supporting organizations. Uh, we'll hit first on church foundations and supporting organizations. The biggest thing here is that these organizations, especially as supporting organizations, they're 501(c)(3)s. They're their own separate entity. They have their own boards. They operate exclusively from the church, but they are often tied in some ways to the church specifically. Sometimes it's through the appointment of board members. There can be similar board members between the church and the supporting organization. But the church foundations specifically, they're not true private foundations as you would think of them. They are truly just for the support of the organization. John, any notes on
Yeah,
either
you
of
typically see these in older denominations, especially in urban areas or maybe older downtown areas that have wealthy benefactors. There's a denomination not far from here, a denominational church downtown area that has what they call the church foundation, right? So it's, First Church and then First Church Foundation. And the idea is that you would put assets into this foundation to protect them from the church's liability. So if the church is ever sued, then they don't have access to this pot of money over here that's meant for the support of the organization. And a lot of times you'll see things like that the foundation will give 4% of its income every year, 4% of its assets every year to the church to help it along. The church can request specific gifts. Usually it's a separate board from the church. It's usually appointed by church members or otherwise. If not documented and organized correctly, these organizations can become separate organizations. And oftentimes, as the years go by, there can be a little bit of dissension between the two, especially if they're well funded, where you have a very large endowment sitting in a foundation governed by people who are not running the church or who believe they know how the church should be run and it's not being run the way they think. And so we have seen some very unfortunate situations where, in some cases, up to $100 million sitting in a foundation that's just sitting there and the board members graciously give 1% of the income of the investment every year to the church because they want to make sure that they keep the reins on how things are going. Now, that's a bit of a dark picture of what's going on. I'm sure they wouldn't see it as the same, but it can happen. So when you're organizing a church foundation, as a supporting organization. It can be a great tool, but we often create at the very beginning through the bylaws and the articles and the processes and procedures, making sure that the church has enough influence into the sporting organization that it's truly supporting the church and isn't going to become this rogue organization that just sits on money and doesn't do anything. So it can be a great tool. We've set up many of them. I definitely recommend talking to us about them if you want, but it can come with some pitfalls if you're not careful.
Another one of the more in-depth tools for estate planning in this area is the charitable remainder trust. So, whereas the charitable foundation and the church foundation as a supporting organization is kind of a bit broader of a topic, charitable remainder trusts are for the individual. They are used as an irrevocable trust, which basically means that the control of the trust is not in the original hands of the donor who's funding the trust, and it will provide an income stream to beneficiaries for a specific term, with the remainder, whatever's left, going to the charity upon either a specific time or the death of the original donor. So oftentimes clients like to use charitable remainder trusts to lower their overall income tax, or not income tax, their death tax or estate tax bill at the end of the day. There's a exclusion amount. To get into the details, there's an exclusion amount that usually you're trying to get below. So this is a great way to take certain assets. It can be stock, it can be cash, it can be property, place it into a remainder trust, and that individual still be able to receive the benefit of that. Of those different means and property, but then the remainder being able to go to a charity upon their death.
Typically, what we see with these is stocks that produce dividends, rental property, commercial rental property, things like that. It's usually property or assets that are creating income, and that income is used to sustain someone until they pass away. It's a great way to do this if you're an individual, if you're an organization that's a church, ministry, charity. Being named in one of these can be great for you. Oftentimes they're irrevocable, can't make any changes. Sometimes you can change out the beneficiary, but it is something that if someone asks, hey, what are some tools? This is a great one to mention and point them to their attorney for to draft, especially if you know they have a lot of income producing assets or property. So
A
take
special
note of
final
this one.
note. Yep. Special final note on these charitable remainder trusts. Oftentimes, the beneficiary of these remainder trusts can be a donor advised fund. It can be an organization like that can then disperse out to multiple charities the assets that are within the trust. That's important to note because the charitable remainder trust can be used for the benefit of multiple beneficiaries. But the next tool that we're going to talk about is can only be used for the benefit of one nonprofit, and those are charitable gift annuities.
Now,
Um,
before we get into this, if you guys have done any type of planned giving or estate planning before and you've heard about these, please know that these are a bit complicated. They have a little bit of a sordid tax history. They are complicated and it takes time. So if you come across any charitable gift annuity forms and you think you can just fill it out and use it, we really do encourage you to speak with legal counsel, specifically tax counsel, CPA about these because this is a little bit complicated. We saved it for the end to see if we even had time to go into this topic because we weren't sure that we were going to cover it due to some of the pitfalls that it has. So, but this is a great tool, and a lot of big institutions use them. So, Sai, I'll let you go in and explain what they are.
Yeah, so basically a charitable gift annuity, think of it as a contractual agreement. So it's not like a will or a trust like we would typically see. It is literally a contract or an agreement where the donor is going to transfer a specific set of assets to the charity in exchange for fixed lifetime payments. Oftentimes the assets that are being given to the charity, especially if it's stocks or cash, those are going to be invested by the charity so that there's some kind of return that the nonprofit or the charity is getting. And so, but the individual making the donation is going to get fixed lifetime payments as well as a partial tax deduction, which we'll talk about a little bit as well. So the partial tax deduction is based upon the estimated amount that will eventually pass to the charity. Again, this is where you're going to have to get an accountant involved. You're going to have to get some professionals involved to make an estimate of what that particular amount is, especially for the donor to understand, okay, this is how much is coming out of my taxable estate for that particular year, or my taxable income for that particular year. Now, the remainder, anything that's left over after the time period, after the donor's original death, is used to support the charity. The charity takes ownership of it, so it can be a really great tool for charities and nonprofits to use. There are, like we said earlier, a lot of specific requirements here. There's the Texas Insurance Code governs these particular types of vehicles. There's notification that must be made not only to the donor, but then there's also organizational requirements. Like you can't, if you charities or nonprofits must have a minimum of 100,000 in unrestricted assets and at least 3 years of continuous operations to enter into these kinds of agreements. So lots of red tape and hoops to jump through. But like I said, the benefits, if you understand them properly, can far outweigh the risks here as well. There are significant fines and penalties for non-compliance, and so we definitely don't want you guys to run into any of those hiccups. So please contact us if you see one of these, if you're thinking about using these with a particular donor, or the donor has brought it up themselves. Let us know.
So, what are some practical next steps for you guys? Well, educating people about this is huge, and we've actually had organizations meet with their donors in mass or individually and say, "Hey, it's one of the things that we want to encourage you to do as an organization that you care about is estate planning and making sure that you understand all the tools that you have. We know you've expressed some desire to support this organization even in your death, and so beginning the conversation, educating them is huge. Next is the navigating the legal and tax considerations. You're not attorneys or CPAs generally. If you work for a ministry in the stewardship department, you may be in a foreign position, and that's great. You may know all about this, but it's okay to say, hey, we need to educate ourselves enough to know when we need to point the donor in the direction of an attorney or CPA. And then policies and preparation. We're going to talk about a couple policies here at the end, uh, and actually have some sample policies for you. If you guys email us and ask for those, we'll send them to you. So we've seen churches do all sorts of workshops. There's ministries out there that'll say, "Hey, we'll come to your church and we'll say we'll do everybody's wills and trusts for you." I will tell you, you have to be a little bit careful with these. Sometimes they're not completely compliant with state law if they're using something they use across different states, or even if they are, they may not be complex enough to meet your donor's needs. But they're not bad, and it could be a real option for you. Our law firm has also done these estate planning, legacy planning kind of seminars for churches before, so that's something that we can do as well for your organization. And then preparing your staff and volunteers. This is really important, and it really goes back to even our discussion at the very beginning about, hey, thanks for saying that you want to leave something to our church. Can we talk about that? Can we get a copy of your documents? Getting them understood that they can have a comfortable conversation with someone if the person brings it up, if the member brings it up. So these are all just terms and things we want you to know about. Tax implications, capital gains, estate tax benefits. Those are things that you need to have some awareness of, that if your members mention these things or they mention that they're looking for these things, we're saying, hey, let's make sure you get connected with somebody to help you out with that instead of letting them figure it out on their own or trying to help them out. Use of 501(c)(2) organizations, know when, hey, we may need to have a conversation about this. Law school, when they take us through law school, it's less about teaching us all of the law and teaching us how to spot different things that make us go, we need to research that. We need to research that. And so these are different things you need to think about. If you're getting a lot of land or someone wants to donate a large chunk of money, hey, we need to think about that. We need to research it. And then compliance, like with charity gift annuities. Um, think about those things. What do we need to do to make sure we're in compliance? And then anytime somebody wants to donate something to you, do your due diligence. You may not want the gift. So you may not want the gift of its cash. And I just want to drop a little point in here. If someone's letting you know, hey, I'm in the middle of bankruptcy or I'm being sued and I would rather the church get all the money instead of me, um, there are things called fraudulent gift transfer acts out there throughout the United States. And if someone's trying to get rid of their money before the court gets it or before a bankruptcy judge gets it, that may be a problem and they may come in after you with the money. Si, do you have something you'll say?
Just red flags. Red flags if
Just
somebody's
red
trying.
flags, just red flags. And then a couple policies for you guys to think about. Especially with gift acceptance policies. There are gift acceptance policies. We've got one drafted, a sample one that you can look at. Doesn't mean you have to use it exactly. But you want to know that you're accepting gifts with the right strings attached or no strings attached. So a gift acceptance policy is a pretty good way to go. It'll help you figure out those things, especially with land. Um, because land is one of those things that can kind of be donated without you knowing it. One of the funnest conversations I had was I was actually merging two churches together and just doing some research trying to figure out the property description for the land that they were going to be donating to another church, only to find out that someone had left them extremely valuable land that they weren't aware of. The person had signed the deed, it's a gift deed, and filed it, and no one from the church knew about it. And so having a policy on accepting land is great way to make sure you're aware of what's going on. Grant policy. Who are we giving money to? Churches and ministries, charities know. People ask for money. Do we have a written in a policy how we handle those situations, what they need, what we need to be able to give a gift, and then drafting gift agreements. How are we drafting gift agreements? Are we doing it in the right way? Are we doing it in a way that helps the organization? Um, we want to avoid disputes. We want to know donor intent. One of the things kind of that goes back to the very beginning about lifetime gifts, the restricted gifts, donor gifts. If you grew up in the church, even 15 years ago, you probably saw when a church was building a building and raising money for buildings, they might have a diorama or a little model in the foyer that says, this is what we're building. There's a reason that churches don't do that anymore. And the reason is because if they needed to make slight changes or drop the scale or increase the scale or do something different, it wouldn't match what donors were told they were giving to. And so it's very important that when you're raising money, that you leave yourself some room to be able to make the changes that need to be made as time goes on. So it's my parting note. So next slide. Go back one. Uh, make sure that you're establishing some sort of a planned giving program. Create a prospect list. Leverage your donor database, collaborate with financial advisors, estate planners, attorneys. They'll be happy to give you resources to reach your organization, your people, as long as they can be a part of that many times. And then churches, educate your congregation. There are benefits to estate planning. Without estate planning and testate success, even if they want to give 10% to the church may never see it. The church may be taking years of litigation if there's not the adequate estate planning going on there. And then prepare for these complex situations. Respond to donor concerns, address misconceptions and clarify intentions, know what you're getting into when you're handling probate and estates, and work with executors and trustees. Like I said, this week we've been asked by a church, hey, will you work with the executor and trustee on this? Will you call their attorney? These are all things you need to be prepared to do. And if you need help in preparing or you have a situation that comes up, feel free to call us. But hopefully this presentation has given you enough language to know what to say and how to say it.
If you guys have any questions, please feel free to reach out to John or I. We have thoroughly enjoyed putting this presentation together. It's something that we're both very passionate about because it obviously affects your organization. It affects your mission. It affects the impact that you're able to have. And so if you guys have any questions, don't hesitate to reach out. And we're very thankful and grateful for this opportunity to share this information with y'all.
And if you do want copies of those policies, that gift acceptance or gift donation policy, please let us know. We'll be happy to send those to you. Thanks, guys, and we look forward to seeing you later.